you filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you file with the
cases that were
court.
cited, and they appear to be, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things.
So, Mr. Gillespie, none of the cases made sense. I have a concern,
Sure,
and I feel that as it is my responsibility, I probably will have to share this with the bar. And Ada Molina Costin Cruz versus Darius Nellums.
Yes, Your Honor, this is Luke Kennedy for the defendants.
And Tristan Gillespie for plaintiffs.
All right. So, Mr. Gillespie, when we were reviewing your documents, your your motion, some of the cases weren't making sense.
Oh goodness, I'm happy to review that and fix whatever needs fixing.
All right, Mr. Kennedy, did you have that issue? Because we were trying to.
I did, Your Honor, and that was something that I wanted to bring up today. So that's part of the reason why I didn't file a reply, is because I was starting to look at these cases that were cited, and they appear to be, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things. And so, for example, Your Honor, on page 2 of the response brief, the Kaplan versus Banks case, I cannot find any case by that name. And
neither could my staff attorney, and she started to question herself. She's fairly new, and I said, no, you've done this before, so let's just ask questions. So, Mr. Gillespie, none of the cases made sense.
Sure, I'm pulling it up right now, Judge. Bear with me one sec.
And in all fairness, I'm going to tell you, I looked you up, so I know you practice in several jurisdictions. I'm not sure if this is something from another jurisdiction, and maybe it's their case law, but it's not Georgia.
Yeah, no, I have this as the Georgia Court of Appeals case from 2008. The Zoom is sucking the speed out of my computer. Hold on one second. I'm trying to actually pull up the case itself. Hold on. So the site I have is Kaplan v. Banks, 289, Georgia Court of Appeals, 193, 2008 case. Got some quotes from it. Big one is on page 194. The negligence of an insurer in failing to answer a complaint on behalf of its insured does not constitute providential cause or excusable neglect under OCGA 91155B.
All right, Mr. Kennedy, tell me where you had issues, and then maybe I can tell you where I did.
As far as the citations go?
Yeah, because the case law, like I said, I wasn't, some of it just wasn't adding up, or I wasn't able to find the sites that were listed.
So that first one, that Kaplan v. Banks, was the first one that I noted that I just couldn't find either a case by that name, or that citation to the Georgia Court of Appeals went to a different case called Hightower versus Cervantes, which analyzed the timeliness of an appeal and had nothing to do with what it was cited for in the brief. The Rowland versus Say case, that 213, it's cited as 213 Georgia App 679. My note on that was that it doesn't talk about anything that was in the Penn site in the brief. It was about abuse of discretion in allowing a defendant to withdraw admissions, and that an occupant of a trailer assumed the risk of injury by walking over a defective floorboard. Nothing about an insurer or agent, not a valid ground to open default. The Henderson versus Quadramed Corp case, I actually cited in my brief for, I think, pretty much the opposite of what it was cited for in plaintiff's response brief. Collier versus State Farm Insurance Company, I did find a case by that name, however, not at the site that was listed in the brief. It was not at 248 Georgia App 264. However, the Collier versus State Farm case was just an insurance contract interpretation. It didn't have anything to do with an answer deadline or resetting the clock, as was cited in the brief. And then the last one I noted was Somerville versus Innovated Images LLC, which was cited by plaintiff and has actually been overturned by Bowen versus Savoy, Georgia, which is 308 Georgia 204 in 2020, which was pointed out in my brief. And Your Honor, I would just also say the timing of the filing would kind of raise some red flags for me as well. And you can, I'm hesitant, I don't want to cast aspersions, but I've seen this has started to become a pattern where the responses to my motions get filed within an hour or two. And I'll just go ahead and tell you, this isn't before you at the moment, but I did file a motion for summary judgment. And that response brief, I was noticing some of the same things. And I know Mr. Gillespie he's been suspended from practicing in Maryland before. And again, I'm not trying to cast aspersions. I'm just telling you, so he's been suspended in Maryland, and part of that was for lack of candor.
Hold on, where is he?
It appears that he either dropped off the Zoom call or lost internet connection.
I got knocked out. I think I'm using too much of my computer's bandwidth or something right now.
So, Mr. Gillespie, I'm a former staff attorney for 2 Superior Court judges. So, and the staff attorneys I'm privileged to work with are really, really thorough, and we check everything. And so my concerns are that not just that we've had some very well-publicized cases where I guess ChatGPT or whatever the legal version of the AI research and writing platform is, but we've had some issues with that where even judges have been dinged because they've, instead of using good old elbow grease and eye shine, they've, resorted to using the platforms. And what concerns me is you're in about 30 different jurisdictions, I swear, between the federal court, 5 different states. I'm a second generation lawyer. I practice in one state because it's easier. You get to know everything. You don't mess up. I had to discourage my uncle, who's a lawyer, from practicing in federal court. I was like, the timing's different. You're old school. You got to practice where you know and where you can be proficient at all of the rules. And so my issue has always been attorneys need to know the rules of where they practice and be proficient in that. And it's hard to do when you're in 5 different states, 27 jurisdictions in the federal court. So what I'm saying is, just listen to me.
Yep.
You risk a reputation, and as lawyers, that's really all we have is our good name and our reputation when you are trying to do too much. And so this brief concerns me because your client is owed a duty of representation, and you owe a duty to be true to the rules of the bar when you raise your hand and swear the oath. And I just need to know what's going on.
Totally understand. And I don't know how to move forward from this other than I'm happy to provide additional briefing copies of the cited cases. Whatever.
Well, I trust that Mr. Kennedy went to a law school, if not the same one I went to. I trust that my staff attorney went to a law school, and reading, research, and writing is the first thing you learn. So if 2 lawyers are telling me that they've had issues, then additional briefing is probably not going to help.
Understood.
I need some kind of understanding of what we're dealing with.
Okay. Well, very good then. Should we? How would you propose we proceed?
Mr. Kennedy, this is also your client's case. Talk to me.
Yeah, Your Honor, I was mulling kind of what to do about it and what to ask for. And again, some of the stuff is going to relate to the summary judgment motion, which is not necessarily before you at this point in time. I would at least ask for my client's fees to be reimbursed for having to be here and respond to the motion or the response brief itself, which I don't have that number right in front of me, but I'm happy to supply an affidavit of what that is. You know, beyond that, I'm not sure if I don't want plaintiff herself to be penalized, so I just want to put that out there. I don't think she should be penalized because I don't necessarily think she has anything to do with this necessarily. It is more.
Well, the brief would, as I understand the statutes, the brief would constitute direct contumacious behavior before the court, which would result in a contempt finding. I wouldn't have to do much extra because it was presented to the court and the contumacious behavior is written in written form before the court. So I would definitely, always back myself up and look again at the statutes before I make a decision, especially on a contempt. But I do believe that in this case, sanctions are warranted, and especially attorney's fees. So go ahead and present your affidavit, and then we'll make a decision on what's to be granted. But Mr. Gillespie, I say this, and I've said this, like, literally my family's replete with lawyers. My brother's a lawyer, my mama's a lawyer, my uncle's a lawyer, I'm a lawyer. The one thing that's been drilled into me my whole life is in the practice of law, it's the only thing you have is your good name. And when you're trying to do too much is when you usually risk losing that. And I get trying to practice in a lot of different areas and do a lot of different things, but it is hard to be excellent when you do that. And so I have a concern, and I feel that as it is my responsibility, I probably will have to share this with the bar. And so there may be consequences that result from that.
Understood.
All right. At the last meeting, the attorney for Caston Cruz, the plaintiff, Mr. Tristan Gillespie, presented a document to the court that had, I guess, was created by an AI application, an artificial intelligence application, and there were cases cited to and presented to the court as legal authority that did not exist. All right, so Mr. Kennedy, I did ask you for your suggestions, any sanctions that the court might issue in this case, but I think I need to hear from Mr. Gillespie first, because Mr. Gillespie, I gave you an opportunity to respond. And essentially, from what I understand, the basis of your response is that you relied upon the app to assure you that it was correct.
That's right, Judge. I'll confess the technology is new to me, and thanks to this case and the motion and Your Honor, certainly much more educated about the pitfalls and dangers and so forth. And clearly, it's not sufficient to rely on large language models to I guess verify or validate case citations, and so much so that we went through the effort and expense of getting proper legal research software, which of course I use solely now, rely on heavily. I think at this point, before we get into a discussion about any possible sanctions, I think it probably would make a certain amount of sense to wait to see what the Georgia Bar thinks of my response. I think it would be premature to impose any sanctions until we saw if they saw any validity to the defense that I raised and that I just explained.
Okay, Mr. Gillespie, apart from what the bar might opine as to the response that you gave, you filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you file with the court. And if you file information that is incorrect, erroneous, untrue, then you're responsible for those filings. You have delayed the course of this case because I could not even undertake the matter, the primary matter that involved the plaintiffs and defendants in this case. I had to spend court time addressing the fact that you sent in a brief that was essentially fiction. And so based on that, what the bar decides to do with respect to your violation of the legal canons and rules that govern members of the bar is separate and apart from your wasting court's time, you're diverting the court's attention from the primary issues in this case, and taking away from the plaintiffs and the defendants' opportunity to be heard. You've elongated this case in a way that wasn't necessary because now the court does not have faith in your ability to represent the plaintiff in this case. I'm appreciative that Ms. Middleton has come into the case to represent Ms. Caston Cruz because I would not feel comfortable going forward with you as the attorney solely representing Ms. Caston Cruz based on your performance here before the court. So, Mr. Kennedy, did you have a suggestion for what you wish to have happen in this case?
Yes, Your Honor, and I did file the motion for sanctions, which you encouraged me to file after our last hearing. And I would just point out, I mean, it's not just like this was one brief, this was several briefs that were filed before the court that contain these same problems. And I think bare minimum under OCGA 915.14, I would ask for my client's reimbursement of all of our fees.
Playing from Tristan's iPhone.
All right, don't know what that
Go
was.
ahead, sir.
Yeah, all of our fees up to this point, because like you said, basically all we've done at this point is deal with these issues. We haven't even gotten to the substance of the case, and it's already been, we're getting close to a year since the complaint was filed. And it's just been a waste of time and an expansion of the case to this point. But I would also ask you to just dismiss this case, Your Honor. I think as you pointed out in our last hearing, the content or the conduct has been direct contumacious conduct to the court. It's written documents submitted to the court as legal authority in support of legal arguments which have no basis in Georgia law and are just fictitious. And we can't live in a system where this is how we operate, and it's just not how the process is supposed to work. We can get into the way this case has gone down too, but we've had issues with getting discovery responses. We've got a summary judgment motion pending right now based on failure to respond to discovery. It's not just only the AI and use of AI, which I'll also point out, you gave him a chance to tell you this last time, and he said nothing. We called it out and we asked him what was going on, and the response was, you want me to provide additional briefing? Or just, oh goodness, not sure how that happened. And now we find out he knows exactly how it happened, and he knew then how it happened, and he didn't tell us. And that's just a violation of the lawyer's basic duty of candor to the tribunal, Your Honor. And I don't think that bringing in another lawyer necessarily absolved all the prior behavior and, sins of counsel, so to speak. And you can just now wash it all away and move on because we've got another lawyer involved. I mean, my clients have been prejudiced by this. We've got significant questions about this case anyways, outside of all these issues, which I'm happy to get into further. But I would ask this case be dismissed and my clients be reimbursed for their fees and expenses up to this point. And I provided you an affidavit as to that number back in August when I filed the motion. It's part of my motion for sanctions, where I also outlined all the instances of the cases that have been either are just totally fictitious or were cited for like a completely different proposition than what they were, than what the cases actually say.
What I do have is a desire to make Mr. Kennedy's clients whole, in as much as he's had to respond to these motions, he's had to spend court time, he's had to spend office time, he's had to address all of these filings, and then the volume of the filings, when really to tell me to file a huge filing, just to tell me that you relied on ChatGPT to tell you that ChatGPT was right. We had a training for judges about the use of AI, and essentially the main thing that was beaten into our heads was you are responsible for everything that is produced, whether you use an artificial intelligence application or not. There are ways to use it to effectively manage the workload of cases and documents and having to read tons of filings, but you can't rely upon, especially something that is open source material at this point, like ChatGPT is open to anybody, and it is not an application specifically for use as a legal artificial intelligence engine. And so at this point, I'm not inclined to dismiss the case, because I really feel like Ms. Caston-Cruz has no clue about the breadth of issues that have popped up that have nothing to do with the merits of this case. However, Mr. Gillespie, I'm not inclined to just wait until the bar resolves it, because that has nothing to do with the fact that you have caused an inexcusable delay, that you have not been candid with the court, that you have not done what is necessary for all attorneys to do, which is to manage your work product and make sure that you are producing products before the court, and giving case law and statutes upon which the court can rely. And so with that being said, the court is inclined to grant the sanctions asked for by the defendant, Mr. Kennedy, and to make those sanctions personally payable by you. They are not to be borne by the party in this case, Ms. Caston-Cruz, or the firm. Those are sanctions that you should bear yourself, because it was you who made the decision to rely upon an open source AI application to file legal documents, and to not go back through those legal documents to ensure that the case law that you presented was reliable, was true, was not erroneous, was in fact actual case law that a court could rely upon. And I saw it, but I can't find it now. What is the amount that you're seeking, Mr. Kennedy?
So as of August, when I filed this, $25,498.08. That's fees and costs.
All right. So, Mr. Gillespie, there will be a judgment against you personally, a sanction against you personally for the amount of $25,000 for $25,498.08 to be paid to Mr. Kennedy. Is that to be paid to your firm?
Yes, ma'am, and then we'll get it back to the insurance company who's paid it.
And Judge, just so I'm clear, that's the entirety of his fees from the beginning of the case till today?
Mr. Kennedy?
That's correct.
I'm not hearing you invite a response to that, but that seems excessive. I understand that that your opinion that I have caused undue time and expense expended by him, but what I have not heard you say is that 100% of all of his time and thus that fee is attributable solely to my alleged transgressions.
Mr. Kennedy?
I didn't go through and itemize like I said, this is just for the whole case. The way I've kind of viewed it is this is all we've been doing in this case so far is basically, him filing, me responding to these types of briefs. But Judge, if you want me to go through and itemize it further, I can do that.
I'm not inclined to do that, and this is why. One brief I could understand, but if this is the tenor of the type of practice that Mr. Gillespie has engaged in this court, and in this case, so I'm not going to nitpick at this point. I feel like from the outset of a case, if you're not practicing law the way you're supposed to practice law, if you are not making sure that you are attentive to the reliability of what you file, the truthfulness of what you file. If you are filing things with no regard to to what your client is entitled to the representation that your client is entitled to, then I do not believe that that is an excessive amount. So $25,498.08. That's to be paid to Mr. Kennedy's firm. That is not to be borne by anyone but Mr. Gillespie.
Judge, is there a timeline you want to put on that?
120 days.
And would you like a proposed order, or will you have one?
Please submit one.
Okay. Your Honor, if I may, I know you've indicated you're not inclined to, dismiss the case on a sanctions ground. Are you planning on taking up the summary judgment motion today too?
Ms. Middleton, you're just coming into the case. Can we get back on track with the merits of the case?